Good morning to all of you. While we are waiting for the presentation to start, I would like to welcome you all. And I see there are still a number of participants entering the room. So before we start, I would like to point your attention to that if you register and if you join this meeting, please insert your full name as in the registration, because that is important for the e-certificates afterwards. All right, but first of all, I want to say good morning to everyone in the Netherlands joining here, and selamat siang or selamat sore to all of you from Indonesia Timur. I welcome you to the first session of this conference about the theme Peace, Justice and Strong Institutions. My name is Jacqueline Vel. I'm from Leiden University's Law School and coordinator of the project that we will present in this session. And we have chosen to highlight how the overall conference theme of From Knowledge to Practice works out in our project on legal education. The general challenge for all of us is how to stimulate that the knowledge generated in international research cooperation also reaches lecturers and students at local Indonesian universities. And that has also been a driving question in the cooperation between the Vollenhoven Institute at Leiden University and several Indonesian universities after we had had a number of research and capacity building projects together. But meanwhile, in less developed parts of Indonesia, university lecturers would really like to improve their courses and teaching skills to face the demands on education from Indonesian society at present. But often they lack the sufficient input for such innovations. In this winter conference session, we will present the approach of the Strengthening Legal Education in Eastern Indonesia project that is funded by the NUFIC Orange Knowledge Program. We will give you an impression on how the project stimulates participation and local ownership, empowering colleagues at less privileged universities, and adapting knowledge from international research to local education demands. Two partners from Eastern Indonesia, a trainer, our law professor, the project coordinator from Leiden, and a process facilitator will give pitches about their perspective in this project. We will end with a panel discussion, and if there's anything you would like to ask or comment on, please type your question in the chat of this Zoom session. Dan boleh juga masukkan pertanyaan dengan bahasa Indonesia, silakan ya. Okay, next slide please. So who are the partners collaborating in the SLEEI project? At the top, you see partners in Eastern Indonesia, local universities in Lombok, Timor, Ambon, and Sumba. It is their practice of teaching law that we are talking about, far from the center of the country and often with less facilities and bad internet connections and low budgets. At the bottom, you see the partners representing the knowledge and expertise of international academia at the law faculty of Leiden University and also at top law schools in Indonesia like UGM in Jogja and Jentera Law School in Jakarta. These partners love to discuss about the content of legal education with each other. But remembering the challenge to stimulate that the knowledge from international research cooperation reaches the lecturers and students at local Indonesian universities, we have another main partner, and that is the Royal Tropical Institute in the middle, which is with its expertise on adult education and intercultural cooperation. All these partners, including the donor organization NUFIC, have their own objectives for this project, but together we align in one program, as we will show you next. So now I would like to ask Herlambang Wiratraman, law lecturer at Airlangga University in Surabaya, working from home in Jember now, and one of the core trainers in SLEEI to explain what the main uniting topic is in this project and why does SLEEI concentrate on Eastern Indonesia. So silakan Pak Herlambang.
Terima kasih Bu Jacqueline. Selamat sore semuanya. Good morning for those in Netherlands. I would like to start with the questions. How do people in Eastern Indonesia, especially, face their daily situations, and how are they related to legal matters? The Indonesian government for more than 20 years, of course, has been trying to encourage development in Eastern Indonesia through various policies. However, this policy, apart from being ineffective in developing the economic of Eastern Indonesia, also did not bring about any fundamental change, especially in relation to the excessive exploitation of natural resources, and often eliminates human rights for local communities, including indigenous peoples. The exploitation is large and massive, such as mining or oil palm plantations. Meanwhile, on the other hand, the poverty rates out of 34 provinces, there are 16 provinces that have poverty rate above the national rate. The 5 provinces with the highest poverty rates are in Eastern Indonesia, includes Papua, West Papua, East Nusa Tenggara, Maluku, and Gorontalo. And it is not surprising that public services are still limited and the community is less benefited in development, such as the health and education sectors. In fact, the role of customary law or any other local laws are still very important in providing the rules of local societies and based on local knowledge of the environment and local culture. But sometimes it clashes up with the state law. The customary law often disregarded or subordinated by the state laws, and hence it easily marginalizes the rights of indigenous people to access natural resources and other basic needs. Therefore, it is necessary to reflect how can law actually protect these common citizens, especially in Eastern Indonesia. Uh, the next slide, please. How can legal education in Eastern Indonesia become more relevant to supporting the rule of law and providing legal services that common citizens need? The state law that has been developed during the New Order regime of Suharto has destroyed customary institutions. For example, it imposed a national uniform uh, system of village governance, also enforcing the rules of state law often runs against the sense of justice that is accepted in local societies. And that is why legal education should address the coexistence or tensions between national and local legal system. Legal education itself is still very much influenced by the monodisciplinary law studies that are dominant in all law faculties in Indonesia. That is why it is necessary to strengthen legal skills and develop more friendly educational alternatives related to human rights issues. By strengthening legal education with excellent capacities, teaching students about fundamental human rights issues, and being sensitive to the law in their local context, it will be of a great help significantly in upholding the Indonesia's rule of law. How can citizens and the lawyers deal with these situations of local versus national law? How to practice law in the local political climate of national economic interest versus local livelihood interests. And SLEEI aims at the strengthening legal education so that law graduates with excellent legal skills who have learned to apply fundamental human rights issues and are sensitive to the customary justice and legal institution in their local context. Any contribution of the project in this direction will be of a great help significantly in upholding the Indonesia's rule of law. And now I would like to give the floor to Rambu Nugroho Wardani, a dean at the Unkris Wina Sumba, who share her perspective from Eastern Indonesia.
Thank you, Pak Herlambang. So, the next question is, what are Eastern Indonesian University's priorities in strengthening legal education? Well, when we started the project, we did a survey at the 4 universities, and the result shows that there are a number of differences in terms of sizes, teaching methods, student assessment, and current level interest and experience. For instance, we do not have law faculty in Sumba, like others. We have law departments as one of 5 departments under the Faculty of Social Sciences. It has 5 lectures and 100 of students. Of course, comparing to other university, they have much more than that. Recently, some lectures in Sumba start to combine their teaching methods, but mostly one only use limited teaching methods. In addition, online teaching is quite difficult to be applied in Sumba because many students do not have a good and free internet connections. Even our students do not have a laptop. The survey findings also show that improvement in teaching method is the priority of the students of the 4 university. In Sumba, students ask for more time to discuss empirical cases, not only local issues, but also national issues. They also ask for more attention to legal practice instead of just theory. At the larger and ranked university, UNRAM in Mataram and Unpati in Ambon, some students explicitly ask for exercises that stimulate their analytical skills, while others stress the importance of more readings. From the lecture side, the top three priorities are improving research skills, developing teaching skills and methods, and enhancing practical legal skills. In specific, lectures in Sumba suggest to develop academic writing skills to support their basic research skills. They also suggest to have better access to teaching materials to improve teaching skills. Currently, in the pandemic time, like now, they suggest to have better skills in doing blended learning, which refers to use IT as one of teaching tools when applying learn from home. Lectures in Sumba also suggest to improve skills for legal analysis, especially to respond the local context, as well as improving their practical legal skills. The baseline study also mentioned 4 recommendations from stakeholders. Firstly, they recommend to a deeper legal knowledge in the field where the institution operates. Secondly, they ask for more and better organized internship. Thirdly, a better ability to the students to use modern technology. And lastly, improvement quality of lectures. So, in short, the answer to the question is that Eastern Indonesian University's priorities in strengthening legal education are revising and developing existing courses which focus on interactive and practice-oriented forms of teaching in order to help students to develop their legal skills, dealing with ethical issues, and become aware of gender aspects as well as the socio-political context of legal problems. That's all. I think that's all for now. Thank you for your attention. And now I would like to give the floor to Professor Adrian Wettner from Van Vollenhoven Institute, Leiden Law School, who is also a SLEEI's project leader and has been involved in Indonesia, Netherlands research and capacity building projects since 2000. Silahkan, Pak Adrian.
Terima kasih, Bu Dani. It's even a bit longer than since 2000 because I've been involved with projects since 1992. That allows me to look a bit back because, of course, SLEEI is not the first project in the field of legal education. So when intensive legal cooperation between Indonesia and the Netherlands started in the 1980s, one of the fields targeted was legal education. And the assumption was that Indonesian and Dutch law shared similar roots and that it would not be difficult to upgrade Indonesian legal courses to a higher level. And another advantage at the time was that there were still many professors and lecturers in Indonesia who could speak and read Dutch fluently and who therefore had direct access to Dutch legal sources. However, it soon appeared that changing Indonesian legal education was not so easy. And the main reason was that Indonesian law was far more complex than Dutch law. Indonesia had not only inherited the Netherlands Indies legal codes, but also its legal pluralism. Indonesian legal scholars themselves often blamed language for the problems. The Indonesian legal language had not developed, they said, and if the language would be put straight, everything would be all right. But the research done by VVI and Indonesian researchers at the time demonstrated that the problem was actually another one. It was decades of authoritarian rule that had inflicted serious harm upon Indonesia's legal system. I lost my line. Anyway, regulations were inaccessible. Important Supreme Court judgments were not published. Doctrinal analysis had lost its relation with legal practice, and the regime used law as a tool for oppression and did not give any rights to people or few. Corruption had become rampant throughout the legal system, and this had undermined its legitimacy in the eyes of the wider public. As anyone can see, these were conditions preventing genuine improvement of legal education. The quality of legal education depends on the quality of a legal system. But it's also the other way around, meaning that the quality of the legal system depends on legal education. In short, Indonesia seemed caught in a devil's circle. The main change followed after the downfall of the new order, when the amendments to the constitution and attempts to improve accessibility to legal sources created conditions for finally building a state under the rule of law. This also applied to legal education. Indeed, over the past 20 years, major steps have been made in this direction, and this makes a project like SLEEI so important, as it will further extend them, not only to universities in Eastern Indonesia, but creating materials and ideas that can also be used elsewhere. Composed of 5 elements, the core of the project, I think it is there to help Indonesian law students on improving their ability for legal reasoning and using different sources of law in that process. It's more than that, but that's the core, I think. Having been involved in many such projects, I have never felt as optimistic as this time that real improvement can be made. Now I'm happy to hand over to Jacqueline Vel, again, the SLEEI coordinator at the Vollenhoven Institute in Leiden, to explain more about the approach of the project. Ibu Jacqueline, please.
Thank you, Professor Bettner. And I'm glad that you are very optimistic about the possibilities for improving legal education. But how can that be accomplished? In the SLEEI project's approach, attention to translation is central. Of course, we take translation literally in the sense of translating papers and discussions from Dutch and English to Bahasa Indonesia. And also the other way around, by the way. The working language of the project is Bahasa, and all the Dutch partners involved are fluent in this language, so that we can really discuss with each other. But translation is also wider. In our experience of international collaboration, we have found that many concepts have a variety of interpretations. For example, students raised under the political regime of repression will have different associations with law and rule of law than those of us who grew up with freedom and democracy. Another thing about translation is that being aware of realities on the ground in the collaboration partnership. Indonesian top universities might have circumstances similar to those in the Netherlands, but most of the universities in Indonesia are not that lucky. and have all kinds of barriers that make improvement of education even more difficult. For example, low budgets, not enough staff, bad internet connections, and little access to literature. So next, please. So that is why the SLEEI activities started with a survey to find out the priorities at Eastern Indonesian universities, as you have heard from Ibu Dani. Next, we discussed the findings in the survey, the plans and the proposed program with all the partners in the inception workshop, which was not like socialisatie, but it was a real discussion. And after we agreed on the priorities, we did not introduce prefab materials from Leiden, but instead started developing tailor-made training materials together. In the slide, you see the activities that lead to course innovation. The green ones are the activities still planned for the next year. A concrete product of SLEEI is the set of 5 core working papers that you see in brown there. With these working papers, we have been trying to find a form in which international academic knowledge becomes accessible to and understandable for lecturers at local universities in Eastern Indonesia. And they might become useful for other universities as well, even outside Indonesia. The working papers have been co-authored and discussed in the Training of Trainers workshop, and then finalized in Bahasa and English. In this presentation today, my colleagues will highlight the themes of legal skills and law in context in particular. The working papers, by the way, are freely accessible from the SLEEI website, and we will show that website at the end of this presentation. The next step in the project approach is that the 4 trainers of SLEEI use these papers as basis for the training they are giving to lecturers at Eastern Indonesian universities. They are further elaborating the working papers into what they call modules for training, including cases and practical materials. These 4 Indonesian law lecturers are the key persons in the SLEEI project. From left to right, they are Herlambang Wiradraman from Universitas Erlangga, Widodo Putro from Universitas Mataram, Ricardo Simarmata from UGM, and last but not least, Bivitri Susanti of Jentera Law School in Jakarta. And now I would like to give the floor to Bivitri so that she can present her example of the training approach in which she has specialized in training legal skills. Silakan Ibu Bivitri.
Terima kasih, Bu Jacqueline. So, ladies and gentlemen, kawan-kawan, why legal skills, you might ask? Isn't it obvious that law schools teach legal skills? Indeed, but the question is how relevant are the legal skills taught in the law schools with the need in legal practice in the society, and how effective are they? Unfortunately, I need to start with a gloomy picture, as gloomy as the sky outside my room here in Jakarta, that very often in Indonesia, legal skills are replaced with skills to make use of legal loopholes and to make use of corrupt law enforcers, unfortunately. This is what we are striving to change, to transform, and we need to start from the source, the students. Now, how do we contribute to the transformation? We understand legal skills as skills to develop sound legal reasoning with special attention to gender equity, ethics, and local context. Sound legal reasoning needs critical thinking and the ability to use different sources of laws, theories, doctrines, and court decisions. Therefore, in our modules, we discuss ways to use court decisions as a tool to analyze cases, steps to develop legal reasoning, methods of interpretation, but most importantly, we also introduce teaching critical thinking skills. So, dear colleagues, I remember my colleague yesterday jokingly said in a WhatsApp group, wow, that is a very challenging question, when he saw a key question in this event flyer. The question is, how can legal education in Eastern Indonesia become more relevant to supporting the rule of law and providing legal services to common citizens' need? It is challenging. So his comment was really relevant. But then what makes us very optimistic is that in SLEEI project, we deal with this challenge in our participatory interaction with the lecturers in Eastern Indonesia universities as participants. We discuss with the lecturers about the need to put aside the conventional method of feeding students with information and then reading articles in law and the like. Instead, we train the lecturers to use court decisions, prepare key analytical questions for students, and be ready to provide feedback with a degree of open-mindedness that can encourage critical thinking among the students. This is not an easy task, but in SLEEI, we not only provide the training on teaching legal skills, but also we equip the lecturers with Socratic method of teaching and provide them with teaching materials, including court decisions that they can readily use, forums in which we can build our project not only as a place to work on outputs, but as a long-term network of collaborative networking. So now it's time for me to hand over the floor to Ibu Revensi from Patimura University Law School to tell us her story from the field. Thank you for your kind attention. Silakan Ibu Vensi.
Thank you, Ibu Bivitri from Jentera. Everybody know who is Ibu Bivitri. Now we talk about how making legal education more relevant to local context and rule of law, an example from Ambon. So we realized that law students need to develop a legal skill, but that alone is not enough to become a lawyer or a judge or a government official who will provide the legal services that common citizens need. Law graduates should also be able to understand law in local context. In Eastern Indonesia, there are other laws than state law that rule in local society, namely customary law. Because 80% of Indonesia's people are still part of customary law communities, this legal system affects many people's life. So in Ambon, we experience that in everyday life. There are many studies, research paper and newspaper article that indicate that this local mechanism to guard social harmony and solve various problems of everyday life in society are very effective. But on the other hand, we have also seen in our recent history in the Moluccas that customary law does not have an answer for all present-day problems and conflicts. Therefore, law students learn how to deal with this legal pluralism of coexisting customary and state law. One example from our law faculty at Unpati is that students learn about the right of indigenous people, in particular right concerning land and water. They learn what the rights are according to customary law. They also learn how indigenous people rights are included in state law and in human rights. And with this knowledge, they have been assisting some customary communities whose land has been disposed, but by helping them to defend their case in court. Some human rights and customary law clash sometimes, but we also need to discuss that with a student. For example, in solving case of violence against women and violence against children in Maluku, usually customary solution prevails. But when in case of violence against children and victims' parents ask for payment of a customary fine in the victim, would that protect children's human right? Another example that is very relevant in the Maluku province concerns sea border disputes. how can the government and all other stakeholders come to the solution? In the ocean law course at Unpati, we are now changing the content of the course so that international law, national law, and customary mechanism are included. We thanks to all the trainer of the SLEEI because the SLEEI trainers help us with this education innovation. Maybe these were 3 examples from Unpati and Ambon on making legal education more relevant to local context and rule of law. And the last, I will give the floor to Pa Laurens van Velhausen from Kid Royal Tropical Amsterdam. Pa Laurens, thank you. Time is yours now.
Laurens, you have to unmute yourself.
And so many things. So it's my pleasure to summarize for you the SLEEI experiences and what it tells about how knowledge can be made to work and to have an impact in practice. Because after all, that is the theme of the conference, isn't it? So I'm going to highlight 4 sort of takeaways. First of all, it's clear that we should not look at the process of knowledge to practice as a linear one, in which imported knowledge from resource organizations is just transferred to others for their use. I think it's clear that what is needed, and particularly when the conditions of the resource organizations and the uses of knowledge are so different, what is needed then is a well-designed process of what is called negotiated sharing of knowledge between all involved. This sharing and negotiation will allow for, and almost always lead to, selection and adaptation of knowledge and insights, so that they are useful and applicable in the user's context. Secondly, in this process, there is an important role for what I call mediators. They are well-informed people who know and understand very well the context of the users, but also the gist of the knowledge content being worked on. And of course, speak the languages of the users in many ways. In SLEEI, you have learned today that the 4 senior Indonesian trainers played this important role in the process. And for this, they received in the project focused capacity building, zooming in on their role as facilitators, not as teachers. To realize a successful knowledge to practice project along these lines, and this is the 3rd takeaway, it needs to give ample attention to the process of interaction between the actors. The project needs to include in its planning activities in which effective sharing of knowledge and negotiations can take place. For this, the project will need to have the capacity to facilitate these events well, ensuring effective inputs from the side of the users. Allowing the users, in our case, the East Indonesian universities, to apply the learning tailor-made to their situation greatly encourages application of the learning. Finally, the bottom line for success is that partners are co-owning the project. What do we mean with that? It means that they see the project as very relevant for their situation and that they have control over activities and budgets at their level to the extent that they have confidence that they can make it work in their local situation. For developing such patterns of co-ownership and motivation, it's obvious that long enough project timeframes are very much needed. So with these 4 takeaways, I hope I have summarized some interesting lessons from the SLEEI project. And with this, I'd like to hand over to Pak Herlambang for the final part of this session, which is the discussion. Terima kasih.
Makasih Pak Laurens. Now is time for discussion, and we would like to invite all participants to have questions or clarification or whatever that you would like to address to our sessions. And we have now questions from the chat column from Ibu Yus Sa'diah And it's good questions. Where is the aspect of decoloniality in the whole grand scheme of this program? And these questions is addressed to all presenters. Who is going to answer first from our team? Adrian, perhaps as a coordinator.
I can make a start.
Okay.
So the question was actually about the post-coloniality, where it is in the project. Well, this is not an easy question, but I can indicate some of it. The first thing which is important, I think, is that we did not start with a whole set of ideas about how we wanted to reform Indonesian legal teaching from the Netherlands. So we really started with looking at the possibilities or the questions and the demand side, so to say, of these universities. What is it that they need? What is it that they feel they need? Not what is it that we as Dutch donors would want them to change. The other thing, which was also mentioned by Jacqueline, is that the working language of the project is Bahasa Indonesia. So we are not at a linguistic advantage. I am now perhaps to some of you, but normally speaking, I'm at a disadvantage as we speak in Indonesian. But this has the upside of this is that it really allows the Indonesian input in the project to be much bigger. The third element I wanted to mention is that we are actually, that it's not the Dutch who are the trainers of the, in the Eastern Indonesian universities. We've been working together with Indonesian trainers, the 4 key persons mentioned by Jacqueline, who are doing the actual trainings in the universities in Eastern Indonesia. So it's much more an Indonesian project where we offer the help we can and ideas, which then are selected and chosen from the Indonesian partners, what they think is most interesting. And that actually produces, I think, a dialogue and a conversation and discussions from which I learn a lot, I have to say, also for my own teaching, and which I greatly enjoy. So it's a real collaborative project, I feel, and I think that is the main thing that is positive from the perspective of making a project post-colonial, so to say.
Terima kasih, Pak Adrian. And I would like to invite Bivitri Susanti to answer from Indonesian side.
Okay, thank you.
Not making a division between Netherlands and Indonesia, but we need to have a perspective from Indonesia. Please,
yes. Thank you, Mas Herlambang, especially that the topic is decoloniality. This is a very good question, Ibu Yusa Dia. I think if I may add, I mean, of course, Adrian has set out the very good foundation for our discussion about the trainers and then the materials. But what's exciting, I think, about this whole project is it's exactly talking about local context. So because we talk about local context, although we don't approach directly about decolonization, decoloniality, and colonization, the past, the history, we don't deal directly with that because we focus on legal skills, local context, gender equity, and ethics. But while talking about that, we use, for example, it's going as far as we even use as local as where we share our knowledge. For example, when we had a workshop in Sumba, we look for court decisions from Sumba. When we discuss with lecturers in Ambon, in Patimura University, we specifically identified and used decisions and cases that they can also be not, in the form of court decisions, but legal cases from Ambon. So I think this is this is how we really can depart from the discussion or dichotomy between Dutch or international influence and Indonesia. We directly touch the local context. So local decisions we don't discuss, except for comparison purposes. We don't discuss anymore for Hochrat decisions from 1921 or 1925. We discuss decisions from for example, the case of Baik Nuril in Mataram, Nusa Tenggara Barat, which was just a couple of years ago. And then we also use materials. Adrian mentioned about how we use materials from different sources, including the doctrines. So we use books from Indonesian law professors and also the body of laws developed in the Indonesian court decisions. So I believe this is adding to the the coloniality of the whole project as the critique to Europe-centric or US-centric kind of teaching law, because we know that that's what's the dominant way of teaching law, especially law, because we talk about business transaction and all that. So I give this back to Herlambang. Thank you.
Thank you very much, Bu Pipip. And we have several questions actually. That's I just want to read those questions. First from Han Arts. What role do you see for moot courts in legal education in Indonesia? Should moot courts resemble and discuss actual legal practices or an ideal court, or perhaps both? And second question from Ibu Yeti. Customary law have been playing a very important role in land ownership in NTT people. How the agrarian law atau undang-undang agraria could support the customary law in NTT and vice versa. And the third questions, saya bacakan saja semuanya. Pak Satria from Surabaya. His question is related to how the measures to reform of legal education, especially for the Islamic universities, for instance, like in Muhammadiyah University. Who would like to address these questions?
I would actually suggest Mas Herlambang to respond to the customary law and the agrarian law questions.
Okay, the second one, yeah, it's related to customary law. The question from Ibu Yeti, yes, actually, as mentioned by Ibu Revensi, and also from Ibu Dani, yeah, mentioning that really customary law is really influential to societies. And of course, since agrarian law as part of Indonesia's legal system, and we have also local laws in our society, then trying to make students more critical in understanding the context of local laws and also the context of state law in particular cases, for instance. And then we discuss together based on very close to the local context in order to adjust and also critically assess what the situations can be addressed in that context. And then we have also during the sessions, of course, we choose controversial or dilemmas cases in order to make sort of like getting more feedback critically from facilitators and also from sharing understanding from the participants. So that's the way to discuss during the legal education process, especially when we have TOT, training of trainers at local context. And then now turn to question Pak Han Arts. Anyone would like to address this about moot courts? Bu Bibip atau Bu Fancy atau Bu Dani?
Maybe I can start. After this, probably others will to avoid awkward silence. So, what role, about the moot court in terms of legal education? So, I would say that moot court is needed in Indonesian legal education. And if the question then is, should moot courts resemble and discuss actual legal practices or an ideal court? Now, this is actually the real question. Of course, we need to introduce in terms moot court. In my opinion, the use of moot court is important to introduce to the students how actually legal procedure is in the court. So what's the correct procedure according to the whatever the moot court is, criminal procedural law or constitutional court regulations and all that. But then usually in the discussion to develop the team for moot court, usually the lecturer should discuss with the students the possibilities where loopholes usually are used by lawyers without ethics, because this is indeed what we need. We address in the project. One of the main topics is ethics, and so if the question is whether we need to introduce an ideal practice, yes, that's what when we do the mooting, then that will be an ideal practice. We won't show anything that is not ideal, but when developing the cases for the moot court, usually there will be discussions, because we will develop the brief together, and that's where the role of facilitating from the lecturers is needed. And in that part, I think it's then important for the lecturers to introduce the unethical actions that can maybe practiced in around the courts. Yeah, so that's for to start the discussion. Mas Herlambang, I give it back to you.
Yeah, just short response to Pak Satria regarding the reform education in especially for Islamic University. We have no specific issue on religious base how to reform the legal education. No, we focus on first legal education at law schools, and second one is in Eastern Indonesia. And then perhaps based on this strategy, especially how to defend, for instance, like local community, we use our strategy by introducing sort of like legal skills how to the students and also lecturers aware on this topic, especially how to deal with the very complicated cases, and also how to bring the message of ethics in that regards, and also trying to strengthen the local laws, which is really influential in our society. So that's the way we are trying to emphasize our legal education process. And we have, fortunately, we have many questions right now from Ibu Yeti, again, it's related to IPR law on local knowledge in NTT. Perhaps Ibu Dani would like to address this. From Ibu Clara, in what way linguistic play a role in law education, local languages, as well as English? And next, the questions to Ibu Revensi. I'm student of law faculty who have learned about customary law. Ibu Revensi can read this. How to apply actually what I've learned about the customary law when I'm facing the problems like land disputes or borders law. Can you give me some suggestion about how to apply my knowledge about customary law? Ibu Fancy can answer this. And the last one is about water rights concerning Rotterdamese people in the NTT. I would like to invite Ibu Dani because several questions related to NTT, or also Pak Lawrence and Ibu Jacqueline because they are expert on Sumba. Please.
Okay, thank you, Pak Herlambang. Well, as I can read, there are some questions about problems, local problems in NTT. And of course, I just can explain only in Sumba case. And I hope Pak Lawrence and Ibu Sheplin also can edit what I'm trying to say. As mentioned before, that this project is very much looking at the local context. And as my experience, the mentor, Pak Herlambang, Pak Ricardo, Ibu Bivitri, and Pak Dwi Putro is focusing in local context in Sumba. I remember when we have a training, Pak Herlambang used the film of local context in Sumba. It's about the land use for investor in Sumba. And so I think this project is very much look at the local context. And I believe they use also the local context in Ambon, in Mataram, and in Kupang. So yeah, I think this is a very interesting for me because then lectures in Sumba can also look at very much clear on the local issues and the local problems. And as I mentioned before, because of these projects, lectures in Sumba is suggest to have a more and more analytical skills, especially because in Sumba they sometimes sometimes asking for inputs of the local context. I think Ibu Sheklin.
Yes, I would like to add something.
Yes, thank you.
Yes, please.
If that's okay.
Yeah, sure.
I would like to say something about the water rights question in NTT. This is actually a very important issue, and this is also sort of controversial issue. We have been talking about the importance of customary law, but regarding water rights, there's often not so many rules available readily for protecting people's water, especially when it comes to larger plantations or new developments like that, in which a lot of water resources are being used. So this is also a matter in which it is important not only to look at the customary law, but look exactly at how in Indonesian state law system, water resources locally can be protected. So this is a point where students, law graduates really need to have insight in all these systems, legal systems together. And regarding the water rights in NTT, I think there's this sort of gloomy picture, especially now with the developments around the omnibus law. It is looking like it's getting harder to protect the very precious local water resources that are there. And that form a basis for local livelihoods. So even more things to do for us as teachers, lecturers, and supervisors in law and legal education on this subject. So thank you for raising this issue.
Makasih Bu Jacqueline. And then the question about linguistic. Pak Adrian perhaps would like to answer this.
Well, actually, I'm really not the best person to answer this question. As I said, we're using Bahasa Indonesia. It's interesting, of course, to note that Bahasa Indonesia also is not the mother tongue of many of the students in Indonesia who go to universities, not only in Eastern Indonesia but also in other parts. So it's always hard to deal with these kind of things. I think important to know is that, of course, Indonesian is the national legal language, Bahasa Indonesia, and that's of course gives it a particular position. What I do think is really important is that we do pay so much attention to local context, and at least we try to admit other languages and other perspectives in the project. Once again, that links to the issue of post-coloniality. So I think this contextual approach is really important. And of course, this is also, I mean, someone like Ibu Dani, Ibu Revensi, they speak the local language, or at least one of the local languages in the area. And that again allows for translation of ideas into another context, into another language, and I think that is you can't get any further if you reject such an approach. Then it doesn't make sense to have collaborations like this anymore, I think. So it's a sensitivity to context and also trying to identify yourself with those who have particular needs, and I think that is the main reason why we're doing this project.
Okay, Pak Adrian, and the last questions. I hope Ibu Fancy answer the questions from student.
Yes.
Silakan, Ibu Fancy.
Thank you for also
1 minute. Is that possible?
Student from Ambon. In fact, that this program is made with several issues in a SLEEI program with gender issue, local context, legal ethics. We have just started with TOT, which integrated a simple issue about the RPS for our teaching in class. Maybe the next goal is perhaps make many training again, but it's depend on the donor. And then maybe if I also want to explain about the mood court. Actually, we love to doing that mood court in Ambon because this is very important to introduce the justice system in Indonesia to a student. But teaching them with various limitations is our problem. But we have tried to teach a student in this practical practice both on a campus and also in a competition, even involving them in LBH when advocating for our community to involve students. But with this program, we try to integrate with the issue of also SLEEI. And the last question for my student, how? Usually my student always ask about this for me, but my answer is simple. Just have a lot of practice and go directly to the field to see various cases related to the indigenous people. That's my suggestion. And the last, maybe read the book. Thank you, Pak Herlambang.
Oh yeah, thank you very much. And I just got a good news from the organizers, Winner Conference, that they can give us 15 more minutes in order to Q&A. So we still have chance to discuss. And then it's up to you. If you still stay here, please continue. But then if you want to move to the other sessions, then it's fine. And now the next question is, I forgot the, ya sudah semua ya. It's yeah, from Ibu Yeti. Oh sorry, from Lalu Arya Nata Kusuma. Ingin bertanya secara langsung. Ya, oke. Is that possible, the host to open him for questions? So, see the way that we open also. I hope all presenters don't mind with the extend for 10-15 minutes. Bisa dibuka, Pak Lalu masih di sini, Pak Lalu Aryanata Kusuma. Tidak. Oh, sudah pergi. Oh, oke. Okay. Any other questions for us?
Okay. Can I ask my question?
Yeah, sure. Please introduce yourself.
My name is Lalu Aryanata Kusuma.
Oh ya, oke. Belum pergi rupanya. Mohon maaf. Silakan.
Okay. My name is Lalu Aryanata Kusuma, and I'm from Universitas Mataram, and now I'm in my 3rd semester. So my question is, as we all know that now we are facing the COVID-19 pandemic, but many law students do not understand about the law lesson because of the ineffectiveness of online learning. A lot of my lecturers don't use Zoom. They just give us material from the PowerPoint. So that's the only place that we are learn about law. So what can we do to solve this problem? Because this is a real big deal, because we can learn about law in effective. That's my question.
Terima kasih. And then who is going to answer? Yeah, Pak Lawrence, please.
Yes.
Well, I don't mind to answer quickly. I fully understand your question. Also, I'm happy to hear the feedback. In the project team with the coordinators from all the universities, we recently discussed this as well, and we are looking for ways to start a number of activities to support the teachers of the 4 universities, including Mataram, to help them improve their skills in online teaching. And we realize that not all of them are used to it and find it difficult, and we have to find a practical way online together with, we are looking for resource people in Indonesia who can do that well. But I think your point is very valid, and of course the capacity of the project is to a certain extent limited, but we've taken up this challenge just after our recent meeting, and we hope to be able to do something about it, to have a number of online meetings, workshops with lecturers to guide them to improve their online teaching, so that they really can reach out to students. Of course, that needs to be based on the interest of the lecturers themselves, to try interested to improve their skills in this important teaching approach that is now needed in times of pandemic.
Okay, terima kasih Pak Lawrence.
Can I add something?
Oh yeah, please.
Maybe this is also a good moment to show that related to this session in the conference, we have together with UNRAM, your university, Pak Lalu Arya Nata Kasuma, and the student organization, they organized a student competition for writing, because one of the things that is always mentioned is we need to practice more writing. So I hope you will participate in this student competition, which is especially for students in the 4 Eastern Indonesian universities. And the whole idea is to practice with writing a blog and starting to think about your own ideas and putting it on paper. So this is just a small example, but I think there are, and we have already been introducing other examples of how to make legal education more than just watching PowerPoints, but introducing all kinds of other ways. Of course, Ibu Bivitri and Pak Herlambang know more about that because they have been actual trainers in this project. Thank you.
Okay, thank you very much, Ibu Jacqueline. Any other questions from participants?
Perhaps a very brief addition to what was just said to Lalu. Well, I think it's mainly the responsibility of the faculty to ensure that there is actually teaching going on, and that actually lecturers do take their task of teaching online seriously. So I would address the leadership of the faculty if you have complaints about the way in which particular lecturers work in this way. I would like to add that in the Netherlands too, there were very different responses by different departments to the situation that emerged after COVID started. And now we see that the faculty is trying that the situation is normalizing, so to say, and that there are guidelines and that there is more clarity about what is expected from you. And I just hope that will also happen in UNRAM and other universities.
Oke, baik. Terima kasih Pak Adrian. And then now, any other questions from participants? If not, then we can conclude or we can end the session. And before ending the sessions, if you see the slide, there is also a student competition for writing a blog about these sessions. And of course, you can do it in Bahasa Indonesia. Students from the 4 Eastern University partner universities are invited to participate writing a blog. Mas Lalu tadi dari Universitas Mataram. Writing a blog will be quite a challenge, translating from English in Bahasa Indonesia, and then writing about ideas you have for improving legal education after you have attended this session. We hope many students will give it a try and submit their blog for the competition. And for further information, you can find the information on the SLEEI website. I think this is the end of our session, and thank you for all for your attention. Terima kasih banyak dan sehat selalu semuanya.
Thank you.
And then now it's the requirement from the host. If you are agree, please turn on your video, and then they would like to have a picture together. Screenshot picture. Anyone here from the host ready for the pictures?
Everybody putting on the video then?
Okay. Baik, kalau sudah semua, then screenshot. I will do it. I will do it. Oke, terima kasih banyak semuanya dan sampai ketemu lagi. Makasih.
Terima kasih.
Thank you very much, Pak Adrian, Bu Jacqueline, Pak Lawrence.